Greetings, everyone, and welcome to this week's episode of Law Chat with John and Amy. I'm John Yulian.
And I'm Amy Polianfico. This week's question is, how much does a divorce cost?
Well, that's one of those questions, Amy, where there's really no black and white answer.
Mm-hmm.
Each case is different based on how many hours the attorney and the attorney's associates are going to spend on the case, because each attorney is charging by the hour. So an attorney is going to require a retainer, which is an upfront fee toward the divorce, and that can vary from one attorney to another. In addition, the attorney is going to charge an hourly fee for the attorney, and then they're going to have a different hourly fee for various associates, colleagues, paralegals. And as a client, you need to be aware of how much the retainer is, which, as I said, is a credit that you have to be used toward the fees. And then on top of it, what's the hourly rate you're paying for the different attorneys and paralegals and associates? It is critical you find this out, and this will vary from firm to firm depending on their size, the experience of the attorneys, and various factors. Amy, maybe you can talk a little bit about what causes such a disparity in the legal fees in various cases of divorce, and why it isn't something where an attorney can say, well, here's how much the case is going to cost.
Yeah, so some of the biggest things are how many hearings are involved. If you have to go to court one time and that's it, you have a deal done and you're maybe going in for one motion hearing, that's going to cost a lot less than if you have a 4-day trial. Just because in terms of preparing for any court dates, the days actually spending in time doing post-trial work, that just adds up. Anytime that a lawyer's in court, you're paying for that time, and that's really expensive. Other factors are how contentious the divorce is. And it also depends on the factor that you're fighting over. If you're fighting over the value of a house, yes, that's going to take time because you're fighting over it, but generally you're going to get each your own appraisal, and maybe you're trying to figure out a middle ground between the two appraisals. Whereas if what you're fighting over is custody, there's not generally, this person wants custody, that person wants custody. It's harder to find a middle ground. It's a much more emotional topic for people. So it takes a lot more to get them to feel like they want to compromise. So that custody, I would say, if someone walks in on day one and it's pretty clear we're going to have a custody battle, I know that is going to be on the higher end of a divorce, just because I can't, with a house or a bank account, I can split it and, you say, okay, we're going to sell it. You each get half. Like, I can't do that with kids. So those are just, you have to reach an agreement. And some person is going to not like it, and that's hard.
Amy, should a client be able to expect the attorney to give an estimate of what the case might cost, or does the client really, I guess, just have no way to have an expectation of the cost, because that seems kind of tough if that's the case.
Yeah. So I don't know what other firms do, but I know that you and I, when we meet with someone, try to give them examples. So normally we have our initial consultation and I've talked to them for a while. I'm trying to get a feel of where everything stands, what they seem to have agreed on already, what are stuff they haven't agreed on or haven't discussed at all, how it seems like they work together. If I know the other party has retained an attorney, what I know about that attorney or that firm to give me an idea of how reasonable they're going to be. And then I try and give a range, and it depends generally. And I do this kind of from experience. I think, okay, well, this divorce kind of reminds me of a divorce like that case. they worked pretty well on custody issues. The big issues were going to be finances, amount of child support. That person maybe had their own self business or whatever. And I try and look back and say, okay, I've had a similar case in the last year that settled for about, I mean, not settled, but got resolved for about this amount. And I give them a range. I think it's going to be, I think that your divorce is going to be somewhere between 8,000 and 15,000, or it depends on the situation. Some divorces are easy and quick, and you guys have everything agreed to pretty much ahead of time, and there's no kids involved, and everyone's a W-2 employee. And I'm like, oh, this one could maybe be for under 6. Other ones, I'm like, you're self-employed. We're going to fight over the value of your business. We're going to fight over custody. You're going to be at least 20,000. I'm not always 100% accurate, but generally I think I'm pretty good at like narrowing down the scope. And if it turns out something changes down the road where it seemed like an issue was going to be an easy fix and it's not, I'll be the first to sit down and say, hey, you guys are fighting over custody. When we originally met, we didn't think that was going to be the case. Like, prepare for this to be more expensive. And then we also just give monthly bills so clients know exactly where they are in terms of what they're billing.
And Amy, that's a great point about the monthly billings, because that enables the client to see where they are in the case, if it's getting more expensive than they anticipated, or not. But if it is getting more expensive than they anticipated, then the client can talk to the attorney about, how much more still is going to occur in the case. Are there things that can be done to maybe reduce the cost, such as certain courts have conciliation programs you can go into, so you don't need to keep going to court and litigating. You can maybe go to a conciliator to try to bring the case to a conclusion. So certainly a client needs to speak up, be aware of the cost, stay on top of it. Like you said, we send monthly invoices. Well, a client should be checking with the attorney to find out, are they going to get monthly invoices, or are they going to get it quarterly, or maybe it's just periodically? Well, those are tougher situations to stay on top of what the costs are. But the client has a lot more oversight, and the more questions and understanding they have of how the fees are being charged and the services being done, the better they're going to be able to prepare themselves for the costs in a divorce.
Yeah, one of the things that we do is if we think discovery is warranted in a case, and we've talked about what discovery is in a different podcast, but essentially interrogatories or requests for productions or a deposition, we talk to our clients ahead.
Amy, can we assume everybody's already seen those prior podcasts?
I mean, why wouldn't they?
I'd hate to think anybody in our audience hasn't watched all our podcasts.
Yeah. Well, if they are curious, they can go back and check another one.
There you
go. But so those are expensive, and so is always a thing and a topic of conversation. I would never send out a deposition request or interrogatories without talking to a client about why I think it's warranted and what we think we're going to get out of it, and kind of doing a cost benefit analysis. Just because those are costs you can't control. Like, I can't control if I have a 9 o'clock hearing and the judge doesn't come out and hear my case until 11, and we're just stuck sitting there for 2 hours. And maybe we're trying to negotiate in the courtroom, but essentially you're paying me to sit there for 2 hours. I can't control that cost. So for costs we can control, like discovery, that is a conversation I like to have with clients.
And to take it full circle back to where we started, Amy, it really does mean the client can't have certainty as to what the divorce will cost, but the client certainly can obtain enough information and an expectation from the attorney as to the range it is likely to cost. And as I say, the client needs to stay on top of the billings and the services being done, so they can best prepare themselves for what the cost of the case is going to be.
And then
that seems, go ahead, Amy.
No, I just wanted to add in, there's a whole other field of divorce mediation where instead of having 2 attorneys, you do mediation. And I can say that pretty much every single mediation we've ever done is cheaper than any traditional divorce we've ever done. So the divorce mediation, if you're the most important thing to you is how much you're going to spend in your divorce, not, having someone to advocate for you. Divorce mediation is the way to go.
Right, and divorce mediation doesn't work for everybody, so
No.
most divorces are still done through what they call the traditional divorce process, not divorce mediation, because many cases just won't be effective through divorce mediation. But if anybody wants to think about divorce mediation versus divorce, of course, that's also available in prior podcasts. So feel free to go check those prior podcasts. Amy, that seems like a good point to end for today.
Yeah, thanks for joining Law Chat with John and Amy. We look forward to chatting with you again next time. If you have a question or comment, feel free to email us at info@ulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Julian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.